listing others to destroy evidence and lie about them. Compare and contrasting to President Trump turned classified documents over to the National Archives and the Department of Justice, and he consented to searching his home and other locations. Wouldn't you say that's night and day when it comes to cooperation with law enforcement?
Congressman, the report does include an analysis and a comparison of the facts that are alleged with respect to former President Trump, and does detail steps of cooperation that the president and his team took with respect to my investigation.
I would say, President Biden, you had his full cooperation in this investigation.
The report includes cooperative steps that the president took.
Would this be a factor in your decision to prosecute?
It was a factor, and I explained it as such in the report, Congressman.
And you stated that the recommendation not to prosecute had nothing to do with the Department of Justice policy not to indict the sitting president. Is that correct?
What the report says that even if it were not current Department of Justice policy that a sitting president may not be indicted on federal crimes, I would reach the same conclusion, that criminal charges are not warranted.
Mr. Hur, have you set new precedent here today?
To the extent that the Department of Justice makes enforcement decisions or non-enforcement decisions in particular cases, those are precedents, those are events that future prosecutors do look to in an endeavor to make sure that federal law is applied consistently over time.
Mr. Hur, I'd say, based on your education and your career experience, you're a very, very competent prosecutor, a very, very well-prepared attorney. I'm going to ask you one more time. Does the fact that you're Republican, does that stop you from a thorough and fair investigation?
No, partisan politics had nothing to do with the work that I did or the report that I wrote or the decision that I reached.
Thank you very much for being here. And Mr. Chairman, I yield.
Gentleman yields back. Gentleman from Wisconsin is recognized.
Attorney Hur, Webster's dictionary defines senile as exhibiting a decline of cognitive ability, such as memory associated with old age. Mr. Hur, based on your report, did you find that the president was senile?
I did not. That conclusion does not appear in my report, Congressman.
You felt, though, that the president's memory or lack thereof was a critical reason to decline prosecution. The reason I'm asking this is whether you believe the president would be fit to stand trial, or do you think his lawyers would argue his incompetence to stand trial due to his state of mind? Also, you know, was he in a place to actually be questioned?
Congressman, my report, to the extent that it addresses the president's memory gaps that we identified in the evidence that we obtained during our investigation, they are addressed in the context of determining how the jury would perceive, receive, and consider evidence relating to whether or not the president had willful intent when it came to retaining or disclosing national defense information.
Very good. I'd like to focus my questioning on Chapter 14 of your report, the classified documents found at the Penn Biden Center. You state in your report that the documents found at the Penn Biden Center were the most highly classified, sensitive, and compartmentalized materials recovered during your investigation. Is that correct?
That is correct.
Many of the documents came from Mr. Biden's West Wing office. That's also correct, isn't it?
I believe that is reflected in the report.
Did you ask if he had packed the boxes himself?
I believe that was one of the questions that we asked, and that is reflected in the transcript now available to the committee.
I think it's important. How would you characterize the packing of these boxes? Was it slow and meticulous, or were they packed in haste without much scrutiny at all?
I don't recall off the top of my head exactly how he characterized it, but I think the gist of the evidence is that the manner in which files were packed up and moved out at the end of the Obama administration was in something of a rushed manner.
Very good. According to your report, the boxes were moved between multiple offices, between Mr. Biden departing his West Wing office in January of 17 and his arrival at the Penn Biden Center's permanent offices in October of 17. Were any of these offices authorized to store classified information?
No.
When the boxes finally arrived at the Penn Biden Center's permanent offices, how were they stored?
I believe when the materials were recovered, some of them were stored in a storage closet, and I believe others of them were in file cabinet drawers.
So what's your
I would refer
assessment?
you to the report.
What's your assessment on security and access control measures at the Penn Biden Center?
That was something that we looked at. There were some security access controls at the Penn Biden Center, but we did get a handle on people who had access to the office space during the time period when we believed the materials were there. And there were other people, including students and some foreign dignitaries, that visited that facility at the time.
Very good. You anticipated my next question. So when the boxes were discovered to have classified documents more than 5 years later, who discovered these boxes? It was Patrick Moore. Is that correct?
Correct. One of the president's personal counsel.
And did Mr. Moore have some type of active security clearance at the time?
No.
How about the executive assistant at the Penn Biden Center?
No.
On page 265 of your
Actually,
report,
I'm sorry, Congressman, I may have misspoken there. I am not certain whether or not that executive assistant had an active security clearance at the time.
very good. On page 265 of your report, you stated, when interviewed by FBI agents, Moore believed the small closet was initially locked and that the Penn Biden Center staff member provided a key to unlock it, but his memory was fuzzy on that point. But an interview with Mr. Biden's executive assistant seemed to contradict his statement. Do you remember this exchange, and did in fact it contradict each other?
Sir, you're asking if I remember the exchange with Mr. Moore during our interview with him?
Right. Do you remember them contradicting each other?
I don't remember that contradiction specifically, but generally during the interview, sometimes we heard things from some witnesses that were in tension with what we heard from other witnesses, and we did our best to resolve those conflicts.
Just very quickly, in total, the National Archives discovered 9 documents totaling 44 pages with classification markings. Is that correct?
From the Penn Biden Center, yes.
And you declined charges because in summarizing your analysis, you couldn't prove beyond a reasonable doubt that retention of the documents was willful.
Correct, sir.
Very good. I yield back.
Gentleman yields back. Gentlelady from Pennsylvania is recognized.
Thank you, and thank you, Mr. Hur, for your testimony today. With all the posturing that we've heard thus far this morning, I think it's important that we refocus and remember the conclusion that you reached on the first page and in the very first sentence of your report, which was, we conclude that no criminal charges are warranted in this matter. Did I read that accurately?
You did, Congresswoman.
Okay. Your report also says, in addition to this shortage of evidence, there are other innocent explanations for the documents we have not been able to refute. Did I read that correctly?
Congresswoman, if you would give me a page citation, I can.
Page 6.
6. Yes, I see
okay.
that language on page 6.
Okay, thank you. Now, in addition to those conclusions, your report details several material distinctions, as you called them, between President Biden's actions and former President Trump's mishandling of classified materials. The facts are that President Biden cooperated with your investigation. Is that correct?
He did.
And his team notified authorities when they discovered classified documents, and he turned them over immediately. Is that correct?
Yes.
He consented to multiple searches of his home and other properties. Is that correct?
Correct.
And he voluntarily sat for an interview with you. Is that correct?
Correct.
But when it comes to Mr. Trump's treatment of classified materials, your report states that, according to the criminal indictment against him, he refused to return classified documents in his possession for many months despite having multiple chances to do so, and he obstructed justice by enlisting others to destroy evidence and lie about it. Is that correct?
Correct.
Now, you noted in your testimony that the specific comments you made about President Biden's memory have gotten a lot of attention. And as we've seen today, our Republican colleagues are again and again trying to weaponize those comments in a cheap attempt to score political points. But as someone who's participated in trials, you know that witnesses, regardless of age, often have difficulty recalling specific statements or facts when asked about them many years after those facts. So let's take a quick look at a differing witness experiencing a lapse in memory during a deposition.
Your next wife was a woman by the name of Marla Maples,
Right.
and sitting here today, do you recall what years you were married to Ms. Maples?
I'd have to get the exact dates for you. I can do that.
Am I correct that you married your current wife in January
I
2005?
don't know relative to that tape.
And what years were you the owner of the Pod Hotel?
I don't know these.
James Webb.
I don't remember the names. Don't remember the name.
So you don't remember saying you have one of the best memories?
I don't remember that.
Okay.
I remember you telling me, but I don't know that I said.
So I would also add that Mr. Trump told lawyers, "I don't remember," 35 times in his deposition for a lawsuit over Trump University. And in response to questions from special counsel Robert Mueller, he answered, "Did not remember," or "could not recall" 27 times. Now, Mr. Hur, you've said today that DOJ process and regulations required you to assess whether a jury would find Mr. Biden to be a credible witness, correct?
I'm not sure that I said those words exactly, but of course, in my view, how a jury would perceive Mr. Biden if he elected to testify in his own defense at a trial, that would be part of the whole ball of wax that jurors would consider in determining whether he had willful intent in retaining or disclosing national defense information.
Sure. Do you have any reason to believe that the special counsel who investigated and charged Mr. Trump with willful retention of classified documents would have failed to make an assessment of whether the jury would find Mr. Trump to be a credible witness?
I don't have any information relating to how, I'm not qualified basically to answer that question as to what went into Mr. Smith's decision-making.
But you are qualified to say what are the normal procedures followed by a special counsel, correct?
I'm familiar with the rules as set forth in the Justice Manual and my understanding of how to apply them.
And in fact, what you did.
Correct.
Okay. So I would suggest that we can all assume that the fact that Mr. Trump was charged with multiple counts of willfully concealing classified documents suggests that the special counsel in that case determined that Mr. Trump's denials are not credible. At this point, I would ask unanimous consent to enter into the record an excerpt from the committee's transcribed interview with Stephen D'Antonio, former assistant director in charge of the FBI Washington field office on July 7th, 2023, in which he explained the urgency for the FBI to retrieve and secure classified documents from Donald Trump's estate because they contained national security information that should not be viewed by anyone without the proper security clearance. Even Mr. D'Antonio himself could not view the documents given their high security clearance, despite being the assistant director in charge of the FBI Washington field office. Thank you.
Without
I yield
objection,
back.
General Lady yields back. Gentleman from Oregon is recognized for 5 minutes.
Thank you, Mr. Chair. I was quite interested in the dates that are set forth in your report, Mr. Hur. And the reason I'm interested is because I keep getting confused between the 2017 date and the 2024 date as to the condition of the president's memory. And so was there a difference? Because when I look at it, it seems like his memory was bad in 2017, and then it was bad today. But there's never any distinction made. But isn't it true that if you were going to be looking at at prosecuting as you were, you would look carefully at his condition in 2017? Isn't that the proper time? Because I think you say in your report that your best case, I think you call it out, the best case for charges would rely on Mr. Biden's possession of Afghanistan documents in his Virginia home in February 2017 when he was a private citizen and when he told his ghostwriter he just found classified material. That's the best case as you say it.
Yes.
And then you work your way through a series of defenses against your best case. So you were looking at his condition in 2017. And do I have that right?
You do, Congressman.
And his memory was bad then. We can draw our conclusions whether it improved over the next 6 years or not. But I just want to make sure it's clear that we're looking at his condition in 2017, which you then find as you go through the list of defenses that is his memory is bad, his memory is bad, his memory is bad. There's about 6 or 7 defenses here. And so what it gets me to is this question. And I actually pulled this quote out of something I read this morning, that perhaps your report concluded, and perhaps it did not, that the president is, quote, incapable of being held accountable. But that's not quite what happened, is it? You didn't find that he was incapable of being held accountable, did you?
I did not. Those words do not appear in my report.
They do not. But you reached a conclusion that you didn't have the evidence, but then your report continually recites these defenses. And I'm having a hard time putting the two together. If you didn't have the evidence, why do you persist in reciting these defenses?
Congressman, I wrote my report as an explanation of my decision to decline charges as to President Biden. And the way that I came up with that explanation and wrote it in my report for the Attorney General is the following. The approach that I took was a prosecutor envisioning what would be the probable outcome of trial if we charged this case, if we presented the evidence to a jury, and not only the government presenting the evidence to a jury, but what would happen if the defense lawyers also got a chance to try to poke holes in the government's case at trial. And with respect to one of the several potential defenses that I lay out in the report, one of them does focus on the president's memory-related issues. That is a defense that the president's defense lawyers may well present at trial. And a jury is going to be confronted with at least 3 separate sets of evidence relating to the president's memory. One is from the recordings in 2016 and 2017 from the ghostwriter.
But if I may, forgive me for interrupting, but I'm limited on time as everybody else was. But you say, I think, that the evidence suggests he is incapable of forming, or you're incapable of proving, intent. There's kind of a bit of a difference there, right? He may well have had the intent, but you could not of holding these documents, and I hate to say hiding the documents, but you couldn't prove it. So what you did instead is fell back to the various defenses that might also be asserted against you. Kind of a heap of rationale for not pursuing the president. Is that, do I have it right now?
Congressman, I think we're on the same page. I think what I'm trying to convey is that the way that prosecutors assess the strengths and weaknesses of their case is to think through, hey, in the government's case in chief, here's the evidence we're gonna present, and the jury might be with us. But that's not the end of the trial. The trial also has to include presentation from the defense lawyers.
You're correct, and I'm a lawyer. I've tried cases, so I get it. Your report is not an exoneration so much as a determination that the evidence as you saw it would not overcome the defenses that you had identified, plus whatever lack of evidence you perceived. So it's not an exoneration, is it?
The word exoneration does not appear anywhere in my report, and that is not my conclusion.
The other thing that's of interest, and I think you were misquoted, you said something about, or someone, I think it was Mr. Raskin, suggested that you, well, I'm going to run out of time, but I appreciate the work you do as a prosecutor, and I yield back.
Gentleman yields back. Mr. Hur, we've been at this close to 3 hours. We will, if you can hang with us, we'd like to keep going. There's a chance we could complete votes by the time we have to go to votes on the House floor, which would be about 1:40.
I can keep going, Chairman.
Okay, then we'll try to do that. There's a chance we may not too, but I just wanted you to know the lay of the land. Now yield to the gentleman from Colorado.
Thank you, Mr. Chairman. Thank you, Mr. Hur, for your testimony and for your service as a prosecutor at the Department of Justice. I want to focus a bit more on the progress of the investigation and kind of some process questions. So you were appointed by Attorney General Garland as special counsel to investigate the president's handling of classified documents in January of 2023, correct?
Correct.
And Attorney General Garland, of course, as you know, was nominated by President Biden to serve in his role.
Correct.
During your 15-month investigation, did the Attorney General attempt to interfere with your investigation?
No.
Did he impede your investigation in any way?
No.
Did any other member of the Department of Justice or within the administration refuse to cooperate with your investigation?
No.
Were you ever denied access to materials, witnesses, resources from Attorney General Garland that you might have needed during the investigation?
No.
You submitted, I think this is right, your final report to Attorney General Garland on February 5th of 2024.
Correct.
Right, okay. And it was then released publicly 3 days later, on February 8th of 2024, is that right?
I believe that's true, yes.
In the final report that was released, were any of your substantive findings redacted or changed in any way?
No.
None of your findings were modified by the Attorney General?
No.
Did the Attorney General issue any kind of statement or a letter attempting to describe the contents of your report?
No.
Okay. You're familiar, I know, I'm sure, with the investigation that was conducted by Special Counsel Mueller years ago with respect to the former president.
Yes.
And at that time, Attorney General Barr was in charge of the Justice Department. He sat where you sat in this committee. I remember it well, just a few short years ago, testifying on the nature of that particular investigation. Are you familiar with the way in which he released that report and characterized it?
Yes.
Okay. Very different from the way that Attorney General Garland conducted this particular release. I take it you'd agree with that.
They were not the same approach.
Not the same approach, right? In the case of Attorney General Garland, no impeding or interfering with your investigation in any way whatsoever, releasing the report in full to the American public, not attempting to mischaracterize it or describe it in any way. Dissimilar from Attorney General Barr, who 5 years ago, as you recall, after Special Counsel Mueller submitted his report to the Department of Justice, took nearly a month to release the report to the American public, heavily redacted, and not before he had issued a letter of his own to the leaders of the Senate and House Judiciary Committees, mischaracterizing the contents of that report. That distinction and difference is very important because from your testimony, at least from what I gleaned from your testimony, is that Attorney General Garland acted appropriately and ethically with respect to this investigation. I take it you agree.
Attorney General Garland did not interfere with my efforts, and I was able to conduct a fair, thorough, and independent investigation.
Very different approach, as you said, from the way in which the Department of Justice, unfortunately, tragically, functioned under the former president. I'm going to yield back the balance of my time.
Gentleman yields back. Gentleman from Alabama is recognized for 5 minutes. Would the gentleman yield for 10 seconds? Gentleman from...
Yes, sir. Mr.
Yeah,
Chairman.
I would just point out to the gentleman from Colorado's last point, there was one big difference. Bill Barr didn't name Bob Mueller as a special counsel. Bob Mueller was named by Rod Rosenstein. That's a huge difference in how this whole thing works. I now yield back to the gentleman from Alabama.
Thank you, Mr. Chairman. Mr. Hur, in your report, you cited principles of federal prosecution and observed that, and I quote, historically, after leaving office, many former presidents and vice presidents have knowingly taken home sensitive materials related to national security for their administrations without being charged with crimes. And this historical record is important context for judging whether or why to charge a former vice president or former president, unquote. Why is examining this history so important?
Congressman, one of the reasons that it was important was because it would bear on how a jury would perceive, how a jury would decide whether or not criminal willful intent was formed by the person retaining or disclosing the national defense information at issue.
Has there been an exception to this in the history of the nation? Have we charged any former presidents?
As I state in the report, to my knowledge, there is only one exception, and that is former President Trump.
Given the history, is it fair to say it's preferable not to charge a former president or vice president for allegedly mishandling classified documents, in your opinion?
Congressman, I can't articulate a preference, whether it's preferable. All I can talk about is the work that I did, the facts that I found, and the decision that I reached in my case.
Mr. Hur, what's the difference in a U.S. Senator having documents and a former president of the United States?
For purposes of proving willfulness, I believe that there would be a number of differences in terms of the types of access and the ease with which presidents, while in office, can access classified information as compared to the access privileges that senators have.
Can presidents declassify documents that they have in their possession?
I believe under certain circumstances, yes.
Former presidents as well?
Congressman, I confess I'm not, this is not an area of the law that I've looked into or explained in my report, and I'm here to talk about the work that is reflected in the report.
Well, let me say this, sir. You have a reputation beyond reproach, and I just want you to know that. I think that President Biden ought to be thankful that the Attorney General appointed you to investigate his case. But you have a special counsel colleague by the name of Jack Smith who cannot lay claim to such a reputation, isn't that right?
I have no opinion. I don't have anything to say about it.
In fact, Jack Smith, whom Biden Attorney General Garland appointed to investigate President Trump, has a reputation, according to deep-rooted reporting from the Washington Times, as an overzealous prosecutor who relies on ethically dubious tactics, unquote. And his prosecutorial record is replete with a quote, let me say this, string of mistrials and overturned convictions. Actually, Chief Justice Roberts once rebuked Mr. Smith's prosecutorial theory as a boundless interpretation of federal bribery statute. That did not comport with the text of the statute or the precedent of this court, according to the Supreme Court Justice. And so, you know, my question is, do you think in the case of Jack Smith, do you think justice is blind when he's looking at President Trump? Since we've never done this in the history of the country, is justice truly blind?
Sir, I'm not here to express any opinions with respect to a pending case against another defendant. I'm here to talk about the work that I did with respect to the investigation relating to President Biden.
Mr. Chairman, I'll yield the balance of my time back to you.
You to this conclusion.
Congressman Jordan, I'm sorry, but the mic was turned on
Yeah.
partway through your
Can you
question.
explain what specifically in your interview with President Biden led you to this conclusion?
The conclusion
That
about how
broad
he...
statement that's been cited many times.
The totality of the time that I spent with the president during his voluntary interview was something that I certainly considered in framing my assessment and articulating it in the report. And that includes not only the words in the cold record of the transcript of the interview, but also the experience of being there in the room with him and, frankly, considering how he would present to a jury in a criminal trial if charges were brought.
But I guess I'm asking specifically. I know you cite in the report the dates that he couldn't remember when he was vice president, when he began, when his term ended. You cite that in the report. Is there anything else specifically that stands out from that interview with the president?
A number of things stand out, and again, I'm aware that the transcript has now been made available. I do provide certain examples in my report of significant, personally painful experiences about which the president was unable to recall certain information. I also took into account the president's overall demeanor in interacting with me during the 5+ hour voluntary interview. So it was a wealth of details about being there in the moment with the president, including his inability to recall certain things. And I'll also say, as reflected in the transcript, the fact that he was prompted on numerous occasions by the members of the White House counsel's office.
That. The brief look I had at the transcript this morning, because we just got it this morning, I saw some of that. Chair now recognizes the gentlelady from Texas, or excuse me, Pennsylvania. I'm used to you being down there. The gentlelady from Pennsylvania.
I got an upgrade.
Okay.
Thank you, Mr. Hur. Thank you, Chairman. Thank you, Mr. Hur, for your service to our country, for your team's service in this investigation. You determined, after what you described as rigorous, detailed, and thorough analysis, that President Biden should not be prosecuted for mishandling classified documents. In fact, everybody can take a look at your report. The very first sentence says as much. It says, quote, "We conclude that no criminal charges are warranted in this matter." Am I correct?
Yes,
That's the bottom line of this report. Am I correct?
that is the first sentence.
It's the first sentence and the bottom line. There's an awful lot of misinformation that has been put forward by the press in some cases and also by the other side of this dais. You didn't reach this decision because President Biden was sympathetic. Is that correct?
I reached the decision based on the totality of the reasons that I set forth at length in my report.
Based on the evidence. And while Mr. Trump, who is being prosecuted, is not sympathetic, you didn't calibrate any of that in there. Sympathetic, not sympathetic. Doesn't matter. It's the evidence, right?
Congresswoman, I did not reach any assessments of the evidence in the Trump matter. To the extent that I considered the allegations against former President Trump, it was for purposes of comparing relevant precedents.
I trust that with your credibility, you were not out to get Mr. Trump, nor here to help Mr. Biden. I think it's about the evidence, and I think you say that over and over again in your report. Why did you decide President Biden should not be prosecuted? Your report tells us, quote, "We conclude the evidence is not sufficient to convict." Those are your words. Is that correct?
I believe if those exact words do not appear in the report, that is consistent with the gist of my conclusion.
Very good. They are your exact words. That was not the case with Donald Trump. You have a copy of your report today, don't you, in front of you?
I do.
Could you read a portion of it for me? Your words, it is page 11, starting on line 3, beginning with the words, "Unlike the evidence involving Mr. Biden." Would you read the next few sentences?
Unlike the evidence involving Mr. Biden, the allegations set forth in the indictment of Mr. Trump, if proven, would present serious aggravating facts.
Keep going.
Congresswoman, I'm happy to have you read the words in my report.
Well, it's your report, so I think it actually is more fitting that you read those.
Most notably, after being given multiple chances to return classified documents and avoid prosecution, Mr. Trump allegedly did the opposite.
Keep going.
According to the indictment, he not only refused to return the documents for many months, but he also obstructed justice by enlisting others to destroy evidence and then to lie about it.
You may stop there. Thank you. You mentioned the indictment against Mr. Trump for mishandling sensitive classified national security information. That indictment says at the end of his presidency, Mr. Trump, I'm looking for my indictment here. I have it here. Hang on. Mr. Trump himself ordered that boxes containing classified materials go to Mar-a-Lago, where he hosted tens of thousands of guests. Then he kept these sensitive materials carelessly about the property, as you can see here. Classified documents ended up in a bathroom, a ballroom, on a floor, spewing about. And when a grand jury subpoenaed the documents, what did Donald Trump do? The indictment again shows against him what he responded by, suggesting that his attorney falsely represent that the FBI and grand jury that he did not have documents called for by the subpoena. He directed his employee, Waltine Nauta, to move boxes of the documents to conceal them from Mr. Trump's attorney, and then lied to his attorney and the FBI and the grand jury, suggesting his attorney might hide or destroy documents called for by the grand jury investigation. Mr. Hur, are those the type of aggravating facts to which you refer to in your report?
Congresswoman, the aggravating facts that I refer to in the report are set forth and described in my report at page 11.
Very good. Mr. Hur, to the best of your knowledge and investigation, did President Biden ever direct an employee to lie about, hide, or destroy classified information? Yes or no?
We did not identify such evidence.
Did he do so himself?
We did not identify such evidence.
And I want to give you a chance, since the transcript is out, to correct the record on an important point. Very sadly, your report on page 208 says that Mr. Biden couldn't come up with the date, the year of his son, Beau Biden's death, when in fact in the transcript it shows that you asked him the month. And do you know what he said, Mr. Hur? He said, oh God, May 30th. Would you like to correct the record? His memory was pretty firm on the month and the day.
Congresswoman, I don't believe that's correct with respect to the transcript, but if you could refer me to a specific page, I'd be happy to look.
I've read about it in reporting. Thank you. I yield back.
Chair now recognizes Mr. Kiley.
Mr. Hur, why did the White House ask you to remove parts of the report? What was the reason they gave for that?
I don't have the letter in front of me, Congressman. I believed that among their reasons was that they contested, or that they asserted that certain language in the report was inconsistent with DOJ policy.
The day that your report came out, the president gave a live news conference on national television. Did you watch that news conference?
I watched the press conference, yes.
What was your reaction to seeing the president personally attack you and your team?
Congressman, I'm here to talk about the work that went into the report and my declination decision and my explanation of it for the attorney.
And it wasn't just the president. Anthony Coley, former spokesman for Merrick Garland, has said that Democrats should focus their ire on her. The president's personal attorney, Bob Bauer, said that your report is a shabby piece of work and a shoddy work product. Do you agree with that characterization of your report?
I disagree vehemently with that characterization of my report.
I also disagree. I think it's very well written, well considered, and comprehensive. Do you think it's appropriate for the administration to be attacking the work of a special counsel that it appointed itself?
Congressman, I'm not going to comment on the propriety of the administration's reaction to my report. What I can tell you is that I stand by the report and the work that went into it.
Today, the ranking member started his opening statement by saying, Mr. Hur completely exonerated President Biden and called your report a total and complete exoneration. Mr. Hur, did you completely exonerate President Biden?
That is not what my report does.
Was your report a total and complete exoneration?
That is not what the report says.
So the statement by the ranking member was incorrect, yes?
As I said, the report is not an exoneration. That word does not appear in my report.
Based on the facts and anticipation of defenses presented in your report, could a reasonable juror have voted to convict?
As I said in the report, some reasonable jurors may have reached the inferences that the government would present in its case in chief at trial.
So a reasonable juror could have voted to convict based on the facts that you presented?
Correct.
If you were on the jury, would you have voted to convict?
I have not engaged in that thought exercise, Congressman, and so what I'd like to stick to is what's in the report, which is my assessment as a prosecutor.
Sure. And what you did find in the report is that the president, you said this is page 200, risks serious damage to America's national security through his handling and mishandling of classified materials. And you identify, quote, a strong motive for the way he handled those materials. Two of the motives you cited was his desire to run for president and his desire to sell books. So a reasonable inference for your report is that the president risked serious damage to America's national security in order to make money and advance his personal political ambitions. Is that correct?
The report includes a description of the evidence and different inferences that reasonable jurors could draw from the evidence.
And you also note that the president described his predecessor's handling of classified materials as totally irresponsible. And your report concludes that Mr. Biden's emphatic and unqualified conclusion that keeping marked classified documents unsecured in one's home is totally irresponsible applies equally to his own decision. Is that correct? You cite as a mitigating factor the fact that the president cooperated in the investigation. But at the time that the investigation was happening and these acts of cooperation occurred, the Mar-a-Lago investigation was already a matter of public record, correct?
I believe that's correct.
So we already had a public debate about the handling of classified documents and the potential application of the criminal laws to that general set of circumstances.
I think that's fair.
And so the president, when he decided to cooperate or not cooperate, had to know that that decision to cooperate or not cooperate would become known to the public and he would be judged accordingly. Is that correct?
I'm not in a position to opine on what was or was not in the president's.
But it's relevant to your analysis as to whether or not it counts as a mitigating factor. If he knew that he was going to have to be judged based on whether he cooperated or not, that would lessen its value as a mitigating factor. So did that, in your analysis, lessen its value?
We undertook a comprehensive
So
assessment.
that specific factor, did it lessen its value as a mitigating factor?
That and all facts relating to the president's cooperation with our investigation.
Another factor you discussed is deterrence. And you say that deterrence actually, the factor actually counsels against bringing charges here, because you said, as for general deterrence, future presidents and vice presidents are already likely to be deterred by the multiple recent criminal investigations and one prosecution of current and former president and vice presidents for mishandling classified documents. So that one prosecution, of course, is the indictment brought by Jack Smith. So by the very terms of your analysis, Jack Smith's indictment actually counseled against and was counted against bringing charges in this case. Is that correct?
I'm sorry, Congressman, I don't follow your drift there.
Well, you said that there's already deterrence because there's this prosecution out there in a prior case related to classified documents. So we don't need to bring another case to establish deterrent value. That was the essence of your analysis, correct?
Congressman, what I'll say is that I will stand by the way and the specific words in which I characterize my assessment of deterrence value of a case under the principles of federal prosecution that's on page 254 and 255 of my report.
Thank you. My time is out, but I'll just add the perverse implication here is that the administration, by the very terms of your analysis, actually made it less likely that the president would face charges by Jack Smith bringing an indictment. Thank you, and I yield back.
Mr. Chairman, I have a unanimous consent request.
Okay.
Thank you. I ask unanimous consent to enter into the record two documents. First, the superseding indictment against Donald Trump in the Southern District of Florida, where he is currently facing criminal charges on 40 counts, including obstruction of justice, lying to the FBI, his unlawful, willful retention of national defense
Without
information,
objection, the indictment
and
is
withholding the concealment
recognized.
of documents from law enforcement, among other things. That was the shortened version. And my second document, to clarify for you, sir, Mr. Hur, from the transcription, page 82, the words are President Biden's. What month did Beau die? Oh, God, May 30th. A searing memory. I ask unanimous consent.
Without objection. The gentlewoman from Georgia is recognized.
Thank you, Mr. Chair and Ranking Member, for this hearing, and thank you so much for spending so much time with us today, Special Counsel Hur. In accordance with the law, classified information must be treated with the highest respect and also protected. And President Biden has made it clear during this investigation and long before that he agrees. In response to Mr. Hur's report, he said, and I quote, "Over my career in public service, I've always worked to protect America's security. I take these issues seriously and no one has ever questioned that, end quote. The special counsel's report makes clear that this is unfortunately a common occurrence for classified documents to get swept up into members of Congress or executive branches officials' personal effects. And as soon as the issue of having classified materials took very different steps. In 2016, Donald Trump declared, and I quote, "I'm going to enforce all the laws concerning the protection of classified information. No one will be above the law," end quote. Yet when his lawyer told him that it was going to be a crime if he didn't return the classified documents that he had after NARA, the DOJ, and the FBI requested multiple times that Trump returned the classified documents, yet he hid them. Trump himself acknowledged that the same year that service members have risked their lives to acquire classified intelligence to protect our country, yet he decided that legal obligation, he also had a moral obligation to all of us, and he failed to live up to that. Mr. Hur, thank you for being here today. I'd like to talk about your report regarding President Biden and some of your findings, yes or no. Please answer this question. Page 187 of your report reads, "At no point did we find evidence that Mr. Biden intended or had reason to believe the information would be used to injure the United States or to benefit a foreign nation." Is this what you reported? For the sake of time, please answer yes or no.
Congresswoman, you said page 187?
Of your report, yes.
Yes, at no point did we find evidence. Yes, that language is on page 187.
Okay, so then this is what you reported, correct? Yes.
That language is in my report.
Okay, and Mr. Hur, you acknowledged on page 12 of your report that there are, as you said, numerous previous instances in which marked classified documents have been discovered intermixed with the personal papers of former executive branch officials and members of Congress. Please, once again, can you confirm for us, yes or no, the answer whether this is what you reported?
That language appears at page 12 of my report.
Page 323 also reads, "As a matter of historical context, there have been numerous previous incidents in which marked classified documents have been discovered, intermixed with the personal papers of former executive branch officials and members of Congress." Is this what you reported?
That language appears at page 323.
Thank you. Now it's my understanding that this has happened before, where classified documents are swept up into official papers. So, Mr. Hur, aside from Donald Trump, are you aware of similar instances in history where officials who have had these classified documents engaged in a months-long elaborate scheme to hide those documents from federal law enforcement officials?
The one case that comes to mind that we do address in the report is the prosecution of General Petraeus.
So, are these historical examples, aside from Donald Trump, where officials instructed their aides to delete evidence pertaining to those classified documents?
That was not present in the Petraeus prosecution, no.
Okay. So the American people deserve, as we've always been saying all along here, that we deserve a leader who will not put themselves above the law, but will work with law enforcement and hold themselves accountable. Thank you, and I yield back.
The gentlewoman from Wyoming is recognized.
Special Counsel Hur, when you determined that no criminal charges should be brought against President Biden in this matter, you focused on the specific facts surrounding the classified documents, where President Biden stored them, and on his memory and age. You wrote that President Biden's, quote, memory was significantly limited during his recorded interviews with the ghostwriter in 2017 and during his interview with the Special Counsel's Office in 2023. You also expressed concern that prospective jurors would be persuaded by President Biden's presentation as a sympathetic, well-meaning elderly man with a poor memory. Your assessment, however, was focused on how President Biden would currently present to a jury if he stood trial. Is that correct?
That was an element of my explanation to the Attorney General for my decision. It was not the only element.
Okay, that wasn't my question, but it was one of the things that we were considering was his current state of mind, his current memory. correct?
One of the things that I considered would be how, if a trial, whenever a trial theoretically were to be held, how President Biden would present himself to the jury if he elected to testify.
Okay. You did not compare President Biden's current memory or condition with his memory or condition when he was in the Senate or when he left the vice presidency and took the classified documents subject to your investigation. Is that right?
Actually, I believe that's not correct, Congresswoman. One of the things that's in the 2016-2017 timeframe, recordings of conversations between Mr. Biden and his ghostwriter, and comparing that with the president's memory that he exhibited during our interview of him in October of 2020.
Issue undisclosed to the American people during his 50 years in office, you found that Mr. Biden fully understood his legal responsibility related to the handling of classified materials, which is why you concluded in your report that Mr. Biden, quote, willfully retained and disclosed classified materials after his vice presidency when he was a private citizen. You state that on page 1, correct?
I believe that what I stated on page 1 was that we identified evidence that Mr. Biden willfully retained classified information after the end of his vice presidency, but ultimately we concluded that the evidence was insufficient to warrant.
I understand that. Please listen to my question. What I'm getting at is that Mr. Biden fully understood that he could not keep classified information at his home as both a former senator and vice president. Isn't that right? He understood that, correct?
My understanding is that based on the evidence, my assessment was that a jury.
That isn't what my question was. Please listen to my question. My question was that Mr. Biden understood when he was a senator and vice president that he could not keep classified materials at his home, at his garage, and in other offices. Is that fair?
I don't think that's accurate, Congresswoman, because when Mr. Biden was vice president, he was authorized to have classified material in his home.
But after he left, he knew that he was not entitled to keep classified information at his home, correct?
After he left, there is evidence to suggest that he knew that he could not legally have classified information in his home. However, there is evidence with respect to his notebooks that he believed he was authorized to keep the notebooks at home based on precedent.
Based on precedent. You know, I guess the way that I would put it is this. President Biden knew better. He knew that he wasn't entitled to keep these documents from when he was a senator, and he knew he wasn't entitled to keep these documents after he had left the vice presidency. But because he's now suffering from an impaired memory, as you so delicately put it, he got away with it. Is that fair?
Congresswoman, what I stated in my report is that there's certainly evidence that some jurors could infer to suggest that Mr. Biden willfully retained and disclosed national defense information. But in my judgment, the likely outcome of a trial, the probable outcome of a trial, is not a conviction.
I have represented a variety of clients over the years in actions against the federal government over, in fact, several decades of time. It's been my experience that the federal government, the DOJ specifically, has essentially unlimited resources to go after and prosecute citizens and will spare absolutely no expense in doing so. It has also been my experience that the DOJ is not only overly aggressive in these cases, but makes it clear that part of the reason for such aggression is to make an example of the poor soul who is the subject of such action. In other words, so that other people will not engage in the same kind of conduct. Mr. Hur, having been a long-term DOJ prosecutor, can you please explain why those people without the last name of Clinton or Biden are typically treated quite differently and seem to be the only ones who are never held accountable for violating the law?
Congresswoman, one of the things that I explain in my report is the fact that there are historical precedents with respect to former occupants of the White House and their retention of classified materials after they leave. So
I'm asking specifically about Mrs. Clinton and Mrs. Hillary Clinton and Joe Biden.
Congresswoman, I don't have any opinion to articulate with respect to the investigation relating to Mrs. Clinton.
I yield back.
The gentlewoman from Texas is recognized.
Mr. Hur, Special Counsel Jack Smith has charged Donald Trump with 40 counts related to his unlawful possession of classified documents. The most serious charge carries a penalty of 20 years in prison. According to the Trump indictment, Trump stored those documents at Mar-a-Lago, which, quote, hosted events for tens of thousands of members and guests, end quote. The indictment continues, quote, Trump stored his boxes containing classified documents in various locations at the Mar-a-Lago club, including in a ballroom, a bathroom, and a shower, an office space, his bedroom, and a storage room. Mar-a-Lago is more than a mansion or a compound. It is a club with membership with a membership program that sells access to the public. It has hundreds of people moving through it at any given time. Staffing it alone required 150 staff members. And while those classified national security documents sat in places like his ballroom, Trump hosted more than 150 social events like weddings and movie premieres, which thousands of people attended. In brief, Special Counsel Smith has alleged that Trump willfully and knowingly took highly classified documents to a location accessible by tens of thousands of people. Mr. Hur, was President Biden's residence accessible to tens of thousands of people?
No.
Did President Biden ever bring tens of thousands of people into spaces where he stored classified material?
Not to my knowledge.
Did Joe Biden advertise and sell memberships to his home that would allow members of the public to have access?
Not that I'm aware of.
Did your investigation find that Joe Biden ever hosted movie premieres at his home while classified documents were stored there?
No.
Moving on, among the 150 staff members working at Mar-a-Lago was a Trump aide named Walt Nauta. According to Special Counsel Smith, Trump ordered Nauta to move boxes of documents so that they could not be found by people looking for them. Mr. Hur, did President Biden ever direct his staff to move documents so that you or the FBI could not find them?
We did not identify evidence of that.
In fact, according to your report, as soon as Bob Bauer discovered material in President Biden's residence, he contacted John Lausch, and the president immediately consented to an FBI search of his home. Is that correct?
My report does state that.
And you found no evidence that any documents were moved prior to that search. Is that correct?
Correct.
That's in stark contrast to Donald Trump. President Biden did not obstruct your investigation. He was fully compliant, and with access to the millions of documents he gave you and dozens of hours of witness interviews he facilitated, you were able to fully and totally exonerate him of any criminal wrongdoing. I thank you, Mr. Hur. And before I yield back, Mr. Chairman, I ask unanimous consent to enter into the record an excerpt from the committee's transcribed interview with Stephen D'Antuono, former Assistant Director in charge of the FBI Washington Field Office, on June 7th, 2023, in which Mr. D'Antuono explained that the FBI executed a search warrant for classified material at Mar-a-Lago because there was probable cause to believe that Donald Trump did not fully comply with a subpoena to turn over classified documents.
Without objection.
Thank you, Mr. Chairman. I yield back.
Gentleman yields back. The gentlelady from Florida is recognized. Oh, excuse me. Gentleman from the ranking member is recognized.
Mr. Chairman, I have 3 unanimous consent requests.
All right.
First, I ask unanimous consent to enter into the record the publisher's webpage for President Biden's 2017 book, Promise Me, Dad, which shows that the book is a deeply moving memoir about the year that President Biden's son, Beau, died.
Without objection.
I also ask unanimous consent to enter page 97 of Mr. Hur's report, which says that President Biden's book is not known to contain classified information.
Without objection.
Finally, I ask unanimous consent to enter into the record a February 5th, 2024 letter from President Biden's counsel to Special Counsel Hur that clarifies that President Biden's 2017 book, quote, does not contain classified information, and there has never been any suggestion to the contrary, close quote.
Without objection. Chair now recognizes gentlelady from Florida, Ms. Lee.
Thank you, Mr. Chairman, and thank you, Special Counsel Hur, for joining us here today to discuss your investigation regarding President Biden's mishandling of classified documents. This has become an issue of great interest to all Americans and, of course, to all of us here today. As is outlined in your report, despite the discovery of confidential and top-secret records located in the president's personal residence in Delaware, including in his garage, office, and basement, the department declined prosecution, and my colleagues' questions today have focused on the highlights from your report, specifically referring to President Biden's mental capacity, his willful disregard for the law as a private citizen, and how he would be perceived if presented to a jury of his peers. Dependent upon, and I'll use your words from the report, how this sympathetic, well-meaning elderly man with a poor memory handled and managed the storage of these confidential documents, the national security of the United States might have been put at great risk because of the president's behavior. And so one of the things we must consider today is how we can ensure that our national security will not be continually put at risk when under the leadership of the same well-meaning elderly man with a poor memory. Since the release of the report, to your knowledge, has the Justice Department started to analyze a damage assessment of what may have been disclosed by these documents being mishandled and any ongoing national security risks from the inappropriate storage and retention of the documents?
Congresswoman, my understanding is that such a damage assessment is underway in coordination and cooperation with the members of the intelligence community.
And do you today, for us, have any information about the status of that investigation or how long it might take to conclude?
I do not, Congresswoman.
I'd like to turn your attention to a discussion of the distinction between proving the underlying elements of an offense and the concept of an obstruction of justice charge. Is it correct, Special Counsel Hur, that in some circumstances as a federal prosecutor, you may investigate the underlying offense, an underlying offense, choose not to charge that offense, but still have developed sufficient evidence to charge a defendant with obstruction of justice?
I think as a matter of law, theoretically, that could occur. I can't bring to mind specific examples of that happening, but I suppose that if that were to happen, it would be a more difficult case to try from a prosecutor's
Well, the elements are distinct, though, are they not?
They are distinct elements.
And isn't it similar to a case where a federal prosecutor undergoes an investigation and ultimately doesn't pursue the original charge they were investigating, but during the course of the investigation concludes that a false statement was made to a federal law enforcement officer and brings a charge under 1001?
That could happen.
Yes. And again, there too, the elements would be different.
Correct.
And in reaching your final decision related to the declination or the recommendation to decline prosecution, you considered both the underlying elements of the offenses at issue and also the principles of federal prosecution. Is that right?
Correct.
Okay. Now, the principles of federal prosecution, those are things that may vary case to case. Is that right?
The determinations under the principles of federal prosecution are very fact and circumstance dependent.
But the elements of the criminal offense are not. Isn't that also correct?
Elements are defined by law, and they do not vary from case to case.
And thus, those elements of the underlying criminal offense would be exactly the same from one defendant to the next to the next. Isn't that right?
Yes.
So you would expect, would you not, that a prosecutor who was considering the underlying offenses that you were considering here would be looking at exactly the same elements and requirements of proof that you did on the underlying charges?
Prosecutors assessing their cases under the same statutes must consider the same elements with respect to those statutes.
All right. Thank you, Special Counsel Hur. And then if we could turn back to the concept of those principles of federal prosecution. Those are the additional factors, aggravating or mitigating, that you might consider in ultimately reaching a charge and decision here. Is that right?
They do include such things that are referred to as aggravating and mitigating circumstances.
There's one thing I want to go back to, though, to be clear. It's been said today that your report is tantamount to a total exoneration of President Biden. That's not correct, is it?
That is not correct.
All right. Thank you, sir. I yield the balance of my time to the chair.
Gentlelady yields back. The chair now recognizes the gentlelady from North Carolina.
Thank you very much, Mr. Chairman, and thank you, Mr. Hur, also for your patience. You're almost to, what, 3.5 hours? So almost as much as Biden. Throughout your report, you repeatedly cite and credit a number of innocent explanations for the presence of classified materials at the president's home and other locations. Innocent explanations that you admit that you cannot refute. And I'd like to just focus on a few of them, and I'll give you citations. One of these explanations for the presence of classified documents is that a member of the president's staff maintained those documents when he was the vice president, and then mistakenly included them in sets of documents that were later sent to to locations such as the Penn Biden Center and the University of Delaware. Is that correct?
I believe that's correct, but if you have a specific page number for me, that would help me, Congressman.
We'll get you one. That would be great. You also found that another innocent explanation to be more likely than a criminal explanation for the presence of classified documents that were found at the Penn Biden Center and the University of Delaware. Is that correct?
Correct.
Great. And then let's talk about the documents in the president's garage. As you noted, a reasonable juror could conclude that the location of the documents, surrounded by household junk, is not a place where a person knowingly and intentionally stores classified documents that are critical to his legacy. Instead, it looks more like a place where a person stores classified documents that he's unaware of. That's on page 209 of your report, correct?
That is something that a reasonable juror could factor into his or her consideration of whether or not the president had criminal willful intent.
Great. And you also noted that President Biden was allowed to have classified documents in his home for 8 years as vice president, and then again when he was president, and that he also had layers of staff who were responsible for assembling, carrying, storing, and retrieving these types of classified documents.
Correct.
And because of these facts, you determined it was, quote, entirely possible that the president did not know he still had some of these documents in his home when his vice presidency ended in 2017. That's on page 215. Entirely possible.
Entirely possible.
Yeah. So that's the citation. I'm going to keep going because my time is running while you're looking. So you also cite the president's cooperation with your investigation as evidence that he did not have criminal intent. And I want to quote you here because this is important. You wrote, most significantly, Mr. Biden self-reported to the government that the Afghanistan documents were in his Delaware garage and consented to the search of his house to retrieve them and other classified materials. He also consented to searches of other locations, and later in the investigation, he participated in an interview with our office that lasted more than 5 hours and provided written answers to most of our written questions. Many will conclude that a president who knew he was illegally storing classified documents in his home would not have allowed such a search of his home to discover those documents and then answered the government's questions afterwards, page 210. And then you said that you expect this argument about the president's innocence to carry real force for many reasonable jurors, because in your words, reasonable jurors will conclude that Mr. Biden, a powerful, sophisticated person with access to the best advice in the world, would not have handed the government classified documents from his own home on a silver platter if he had willfully retained those documents for years. Just as a person who destroys evidence and lies often proves his guilt, a person who produces evidence and cooperates will seem by many to be innocent. Again, page 210. As you said in your report, it would be reasonable for a juror to reach that conclusion, and that a president advised by counsel would not have informed investigators of the presence of classified documents in his home or invited agents in the search of every nook and cranny of his home or other residence, or sat for an hours-long interview or answered pages of written questions all going to his full cooperation and his lack of criminal intent. Thank you, Mr. Chairman, and I yield back.
Gentlelady yields back. Mr. Hur, we got.
Employee of the Department of Justice, I would refer you to the White House and DOJ leadership.
You're an accomplished lawyer. Is there any reason why we shouldn't? Why the United States Congress shouldn't have access to the same information you had access to, and that was the basis of your decision?
Chairman, it is not for me to opine on what materials.
Well, the Justice Department released the transcripts the day of the hearing. It'd been nice if we'd had them at a more, I think, a better time for the committee to prepare for our questioning for you. They released them today. The White House and the Justice Department released them today. It'd be nice if we actually had the audio tapes too. Again, is there any reason why you can see why the American people and their representatives in the United States Congress should not have access to those tapes?
Chairman, what I can tell you is that my assessment that went into my conclusions that I described in my report was based not solely on the transcript. It was based on all of the evidence, including the audio recordings.
Great point, and that's where I was going. So this was valuable evidence for you as the special counsel named to investigate this issue, valuable evidence for you to reach your conclusion, and the statements you put in your report. And all I'm asking is, shouldn't the United States Congress have access to that same information?
Chairman, again, it is not for me to weigh into what information Congress should or should not have, but what I will tell you is that the audio recordings were part of the evidence, of course, that I considered in coming to my conclusions.
I will yield back to the gentleman from Kentucky and hopefully can yield to the gentleman from North Dakota.
Yield to the gentleman from North Dakota.
Thank you, Mr. Hur. In Chapter 8 of your book, or your report, you detail that Mr. Biden retained in his Delaware basement classified documents relating back to his time as a U.S. Senator in the 70s, correct?
Correct.
And even more Senate papers dating back to the 70s through 1991 were found in the University of Delaware, Morris Libraries, and in the Biden Senate Papers collection, correct?
Correct.
And even more Senate papers dating back to the 1970s and 1980s were found in Biden's Delaware garage.
I believe yes, that's correct.
And quote, Mr. Biden had nearly 50 years experience dealing with classified information, including as a member of the Senate Select Committee on Intelligence, a member and chairman of the Senate Committee on Judiciary, a member and chairman of the Senate Committee on Foreign Relations, and Vice President of the United States. And that he was deeply familiar with the measures taken to safeguard classified information and the reasons for them, correct?
That language certainly sounds familiar, Congressman, but if you have a page citation for me, I can confirm.
And as Vice President, is it correct that in 2011, Mr. Biden received advice from his staff about the need to secure classified information in the form of notes?
Correct.
Including his first counsel, Cynthia Hogan?
Correct.
And he was advised in writing in 2011 by Hogan that classified notes must be obtained in secure safes and stored in secure facility.
Correct.
His second counsel, John McGail, also advised Biden that all of Mr. Biden's records, including his notes, would be sent to the National Archives, and Biden understood and accepted that, correct?
That's correct, with the exception that Mr. McGrail was Vice President Biden's final counsel, not his second one.
All right. And on his way out, Mr. Biden was also appraised of his obligations by the National Archives staff twice more that his classified notes should be secured in a SCIF.
That particular fact is not immediately coming to mind, Congressman, but if you have a page citation, I can confirm it for you.
Well, did Mr. Biden have 30 years' experience handling this information? He received advice from at least two separate counsels, the National Archives staff. He has demonstrated enough knowledge of the law to attack President Trump in public over the same exact issue in detail. This is where I get into this. I just have a problem with this. In your report and this testimony, a reasonable person would conclude that Mr. Biden knowingly retained national defense information and failed to deliver it to an appropriate government official, and that he knew his conduct was unlawful. And I think that's where we end up here, and that's what the point is. Over the last 3 election cycles, there's only been 3 people who have ran for president: Hillary Clinton, Joe Biden, Donald Trump. All 3 of them have been accused of mishandling classified documents. Only one of them has been prosecuted. And that's what the American people see. That's what we see. We had Hillary Clinton, who ran a program called Bleach It on her server. They used hammers to destroy evidence. Joe Biden has a 50-year history of misplacing classified documents in numerous different places. All of these cases have the same underlying elements of the crime, the same fact patterns, and yet we only see one person being prosecuted. And with that, I yield back to the gentleman from Kentucky.
When time's expired, I yield back.
Gentleman yields back. The ranking member is recognized for unanimous consent.
Thank you, Mr. Chair. Mr. Chairman, in light of what the chairman previously said, I ask unanimous consent that all transcribed interviews taken by the committee this year be made public.
There's an objection to that. The gentlelady from Missouri is recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you for being here, Mr. Hur. St. Louis and I are here today once again to focus on the real issues that affect our communities instead of partisan hit jobs. Let me start by saying that the potential mishandling of classified information is a serious issue, and I believe it was appropriate for the Attorney General to appoint both special counsels in the Biden and Trump cases. As my colleagues have pointed out, President Biden fully complied with the investigation conducted by Special Counsel Hur, who did not find evidence sufficient to warrant criminal charges. Despite this outcome, Republicans have used the special counsel's report to further their longstanding efforts to re-elect the former white supremacist in chief, Donald Trump, who faces 40 criminal charges related to the mishandling of classified documents, including obstruction of justice. While President Biden returned all of the classified material and complied with the special counsel's investigation, let's remind ourselves what Donald Trump has said and done. He refused to turn over the classified documents in his possession to the National Archives. He is on tape sharing documents he said he could have declassified when he was president. He wrongly claimed in an interview that the Presidential Records Act allows him to do whatever he wants, and he was allowed to do everything he did. He also said on his right-wing social media platform, quote, "I'm allowed to do all of this." He continues to admit to his possession of these documents on the campaign trail. So this hearing is not a good faith oversight effort. It is just the latest in a long line of dysfunctional and destructive actions taken by this Republican majority. They don't care about responsible governance or making people's lives better. They don't have an affirmative agenda. They are throwing whatever they can at the wall and hoping it sticks, and they have zero credibility to talk about mental acuity when they support Donald Trump. The same Donald Trump who mixes up Joe Biden and Barack Obama and Nikki Haley and Nancy Pelosi. The same Donald Trump who incorrectly pronounced the words Venezuela, respected, and United States. The same Donald Trump who calls January 6 defendants hostages. And the same Donald Trump who believed bleach injections would treat COVID-19. It is deeply hypocritical for anyone who champions this man for the presidency to talk about the mental acuity of anyone else. But this is nothing new. This has been a consistent pattern of the Republican majority in this Congress. From the sham impeachment investigation that has completely collapsed to the absurd impeachment of Secretary Mayorkas, Republicans have solely focused on destroying the incumbent president, destroying the Democratic Party, destroying progressive movements for social justice, all so that they can re-elect one of the worst presidents of all time. Now, it is well known that I have disagreements with President Biden on certain issues. My concerns are rooted in the desire to resolve policy matters and help him take better positions that save more lives. That's not what Republicans are doing. That's not what these investigations and attacks are about. They are trying everything they can to turn back the clock on our rights and our freedoms, and we cannot take the bait. Let's focus on policy. Let's focus on substance. Let's focus on saving and improving the lives of our constituents, not misusing the precious time and resources of this committee, not being dishonest just because it serves our political interests. We are better than that, and our country deserves better than all of this. I will continue to reject these absurd distractions from the investments we need in the communities that we represent. Let's focus on that instead of this irresponsible and easily repudiated Republican clown show. Thank you, and I yield back.
The gentlelady yields back. I recognize myself for 5 minutes. Special Counsel Hur, thank you for a number of things. First, thank you for agreeing to testify today. Second, thank you also for sharing your family's story at the beginning of your testimony. It is an extraordinary story of them coming to America. Third, let me also thank you for your in-depth investigation and your detailed report, and generally for your service as special counsel. It's not something that I think many people would look for, and certainly comes with a lot of burden, so thank you for your work. In your opening statement, you described your investigation as, quote, thorough and independent, and I agree with that. One where you attempted to give, quote, rigorous and detailed analysis. I also agree with that. And one where you say you, quote, must show your work, which we very much appreciate today. We don't normally see that. Did I recall your opening statement correctly as it relates to those quotes?
Yes, sir, you do.
In fact, as part of your investigation, you interviewed about 150 different witnesses. You looked at millions of different documents because you wanted to do a thorough investigation. Isn't that true?
Correct.
And you did this because you took your investigation extremely seriously and you wanted to reach accurate conclusions, correct?
Very much.
Then let's review some of your specific findings regarding the issues pertaining to competency and mental capacity of President Biden. Because as you say, this is very important to whether or not there was criminal willful intent. As you can see, I've set forth a number of different quotes up here on this board that I've prepared, some of which I'll read to you. Page 5, you say, Mr. Biden's, quote, Mr. Biden's memory was significantly limited. Then again on page, as a sympathetic, well-meaning, elderly man with a poor memory. Then on page 207, you say, Mr. Biden's memory also appeared to have significant limitations. And then again on page 208, he did not remember when he was vice president, and he did not remember even within several years when his son Beau died. You finally make the statement on page 248, quote, for these jurors, Mr. Biden's apparent lapses and failures in February and April 2017 will likely appear consistent with the diminished capacities and faulty memory he showed. Those were astounding conclusions to me, and as I look through those quotes, I have to say I hearken back to my time before Congress. I was a judge, and one of the things that I oversaw was guardianships. And frankly, when I read your conclusions, red flags began to go up in my mind because I oversaw hundreds of guardianships back in Texas. And as I saw your conclusions, I began to wonder, what does the D.C. statute say about guardianships, and how do you define an incapacitated individual in Washington, D.C.? And I want to show you this statute because I presume, are you familiar with the statute at all?
I am not, Congressman.
So I didn't think that you'd probably reviewed that. So let me just read to you some of these, some of the definitions here. An adult whose ability to receive and evaluate information effectively or to communicate decisions is impaired to such an extent that he or she lacks the capacity to manage all or some of his financial resources. That's the first part of the definition of incapacity, an incapacitated individual under the guardianship statute in the District of Columbia. And quite frankly, I see tons of overlap from what you set forth in your testimony, in your written report, and the definition here. The phrases are almost identical. I would posit that if he cannot manage national top secret resources, I'm not sure how he can manage his personal financial resources. And given your report's findings that his memory was, quote, significantly limited, and that he is a person with, quote, diminished faculties, and with, quote, faulty memory, it makes me wonder how close he is coming to meeting this definition of an incapacitated individual, such that he should have a guardian appointed by the D.C. courts for his personhood. There is at least, I believe, a prima facie argument to say that there is substantial evidence to indicate such. And you mentioned it's not just what you written in the report, but it was the demeanor of President Biden as you interviewed him. I'll say in conclusion, whether he does or does not meet this definition, I believe your findings raise significant concerns about his current fitness for the office of the president, and certainly his fitness going forward in the future. And I appreciate the fact that you were brazen enough to raise this issue in this report because you knew this would be significant in your findings, but you did so based on a very significant, very detailed, very thorough, independent report, and I praise you for that, doing your duty in such a way. Thank you, Special Counsel. I yield back.
Gentleman yields back. Mr. Hur, we have votes on the floor. We have a few more members who will do their 5 minutes of questioning. So we're going to recess, and then we will convene 10 minutes after the conclusion of the last vote. I believe we only have a couple votes. Is that right? 2 votes. So, but you know, Congress, that'll take a while. But we'll get back here as soon as we can. And There's food in the back room for, I think we still have some left that you're welcome to. With that, we stand in recess until 10 minutes after the last vote. We have former colleague of ours, Mr. Bratt from the great state of Virginia. Welcome to the committee. Mr. Hur, we will now go to the gentleman from Maryland for 5 minutes. Mr. Ivey.
Thank you, Mr. Chairman, and Mr. Hur, appreciate you coming in today. I did want to deal with one preliminary matter, which is the issue of the release of the transcript. I've heard complaints from my Republican colleagues about the White House only releasing the transcript from the Biden interview this morning. But I have to note that there are, I think, over 90 transcripts that are being held by the majority here in the Judiciary Committee and Oversight Committee for interviews that we all care about. They all go directly to issues with respect to the alleged impeachment inquiry. It's kind of the pot calling the kettle black, it seems to me, as an understatement. So I noted, too, that when the ranking member requested the majority release the transcripts, the chairman objected. So I hope that we can move forward in the mode of cooperation and sharing information. I think it's just reasonable to do. Mr. Hur, I wanted to thank you again for the work you did. I don't agree with everything you wrote in the report, but that's the nature of the business, I think. But I did want to ask you about this. I know you started off with, in the first line executive summary, we conclude that no criminal charges are warranted in this matter. And I take it that's still your position today.
Yes, it is.
All right. You also noted a little bit below that, for the reasons summarized below, we conclude that the evidence does not establish Mr. Biden's guilt beyond a reasonable doubt. You still share that, still hold that view?
I do.
Okay, and even though you objected to the use of the word exonerated, from your perspective, he's been cleared of all criminal charges in your investigation. Is that fair?
I determined that based on the evidence, criminal charges are not warranted.
Okay, and I did want to go to the issue of material distinctions that you raised in your report between President Biden and former President Trump. We've got a document up here that lays some of it out, and you've answered some questions about this already, but I think it seemed to be highly relevant in your analysis that President Biden cooperated, and I wanted to walk through a couple of those points. One is that he turned in classified documents to the National Archives and to the Department of Justice upon request. Is that fair?
That was a factor that we considered, yes, Congressman.
All right, he cooperated with your investigation?
Yes.
Consented to the search of multiple locations, including his house?
Correct.
Sat for a voluntary interview?
Yes.
And that was 5 hours over 2 days?
A little over 5 hours over 2 days.
Okay. Turned over and allowed investigators to review handwritten notebooks he believed to be his personal property?
Correct.
Now, with respect to the comparison with former President Trump, and I believe this is on page 11, which is still in your executive summary. And I'll just read part of this to you. Unlike the evidence involving Mr. Biden, the allegations set forth in the indictment of Mr. Trump, if proven, would present serious aggravating facts. Most notably, after being given multiple chances to return classified documents and avoid prosecution, Mr. Trump allegedly did the opposite. According to the indictment, he not only refused to return the documents for many months, but he also obstructed justice by enlisting others to destroy evidence and then to lie about it. In contrast, Mr. Biden turned in classified documents to the National Archives and the Department of Justice, consented to the search of multiple locations, including his homes, sat for a voluntary interview, and in other ways cooperated with his investigation. That's from page 11 of your report?
I see that language on page 11.
All right, and you still stand by that language?
I do, sir.
Okay. And this is this is your report. You take full responsibility for everything that's in the document?
I do. I stand by every word in it.
All right, all right. Wanted to ask you a couple of questions. One is with respect to the surprising line of questions you got right before we broke about guardianship, which seems to me like a dramatic stretch of the anything that was remotely involved in your report. Did you raise any kind of issues about Mr. Biden needing guardianship or anything along those lines?
Nothing relating to guardianship appeared in my report.
Okay. And so I guess you made the one point about him being an elderly man with poor memory, but are you saying you Did you say anywhere in your report that you thought not only would he be unfit to handle his own finances, but he'd be unfit for public office?
My report did not include any opinions on those issues.
Okay, I see my time is exhausted, but thank you again for your testimony. I appreciate your efforts.
Gentleman yields back. Gentleman from Virginia is recognized.
Yield to the chairman briefly.
I think the gentleman for yielding, I'm just pointing out Mr. Ivey raised the issue of transcripts. He has complete access to every transcript that we have done in a congressional investigation. He can go, he could show up for all the depositions, like frankly, I show up for most of those. So he has complete access to that. What we don't have is access to the transcripts of all the witnesses. We only have Mr. Biden, and we don't have access to the audio tapes of all the witnesses, which is what we're
Will the gentleman
seeking.
yield?
It's not my time. I yield back to the gentleman from Virginia.
You're speaking, but it's not your time?
It's my time.
You yield it to me.
All right.
I thank the gentleman. Special Counsel Hur, thank you for being here. Your story is an impressive one. Your achievements are impressive as well. You've been a prosecutor for many years, correct?
Yes, sir.
I was not a prosecutor for more than a couple of years, but I still remember my record in jury trials. Do you remember your record?
It'll take me a little time to reconstruct, but I think I could get there.
Is it above 500?
It is above 500, yes, sir.
Okay. Well, I'm curious because the evidence that you outlined in your report is pretty significant when it comes to evidence that after his vice presidency, and I'm reading from your report, Mr. Biden willfully retained marked classified documents about Afghanistan and unmarked classified handwritten notes in his notebooks, both of which he stored in unsecured places in his home. Further, you noted that there's evidence that he willfully retained the classified Afghanistan documents, including the Thanksgiving memo, and had a strong motive to keep such classified documents. You outline what that motive is. Can you tell me what is the motive for keeping the Thanksgiving Day memo?
One of the motives that we addressed in the report was that the issue of whether or not a troop surge should be sent to Afghanistan in 2009 was a hotly contested and debated issue within the Obama administration back in 2009, and one in which then Vice President Biden had a significant role and he felt very strongly about.
I'm going to quote from your report. President Biden believed President Obama's 2009 troop surge was a mistake on par with Vietnam and wanted the record to show that he was right about Afghanistan, that his critics were wrong, and that he had opposed President Obama's mistaken decision forcefully when it was made, that his judgment was sound when it mattered most. Does that sound correct?
That language sounds familiar from the report, yes.
Okay. That is pretty significant in terms of a motivating factor for retaining those documents, wouldn't you say?
That would be a factor that a jury would assess in considering whether or not Mr. Biden had criminal intent.
And I also know that President Biden was working with a ghostwriter on a book, Mark Zwanecker, correct?
Correct.
And your investigation concluded when President Biden began work on his memoir, correct? At what time did your investigation conclude?
With respect to the second book published in 2017, we identified evidence that Mr. Biden began recorded conversations with Mr. Zwanitzer in 2016 before the end of Mr. Biden's vice presidency.
And it's your understanding that while Mr. Zwanecker interviewed President Biden, he read classified information from his notebooks nearly verbatim, sometimes for an hour or more at a time, correct?
Correct.
And was Mr. Zwanetter authorized to receive this classified information?
He was not.
And in fact, in their February 16th meeting, which has been alluded to earlier, isn't it true that President Biden read aloud and nearly verbatim classified information regarding the actions and views of U.S. military leaders and the CIA director relating to the foreign country and a foreign terrorist organization?
I believe that occurred, that was captured in a recording later in 2017, I believe in April of 2017, not February.
Okay. And Mr. Zwanetter became aware of your appointment as special counsel, correct?
At some point, Mr. Zwanitzer did become aware of my appointment, yes.
And upon learning of the investigation, Mr. Zwanetter deleted digital audio recordings of his conversations with Mr. Biden.
Correct.
Did investigators with your office interviewed Mr. Zwanetter about the deleted recordings?
We consider it to be significant evidence that we needed to follow up on.
Significant evidence, and significant evidence surrounding documents.